Good morning or good afternoon. I think that now we can start. Hope everybody's listening me well. If you're not speaking in this event, I will kindly ask you to mute your...
We had to embark or do that.
Yes, exactly. Thank you very much. So if you can mute your speaker, if you're not speaking to this event, I would appreciate very much. Okay, great. So today we're going to talk about climate litigation and advocacy and link those subjects to litigation funding. The idea here is to tell you a bit more about how litigation and litigation between private parties can help to tackle climate change and the importance of advocacy alongside this endeavor. Also, for the last part of this panel, we will discuss what is the importance of funding for all those causes and how funds just like SPS that we will talk about can help us with those goals. This morning or this afternoon, I am joined by Pedro, Tomás, and another Pedro in this panel. I ask our Brazilian colleagues to excuse us because we will be talking in English, despite the fact that we are all Brazilians, for the convenience of people around the globe listening to us. Good morning for our panelists. I will introduce you to give you a brief introduction about who they are, but please feel free yourselves to introduce yourself if something is missing. So we'll have today Pedro Artung. He's a legal policy and advocacy specialist and researcher on human rights and children's rights. He's also head of legal policy at ALANA, an institute whose mission is to honor Brazilian children through advocacy practice. Hello, Pedro. We are also joined today by Tomás Jatobá. Tomás, he's a lawyer and also co-founder of SPS Capital, a prominent Brazilian asset management firm for special situations and strategies, including funding of litigation. I'm proud to say that SPS funds some of our climate litigations that are led by PGMBM. Good morning, Tomás.
Morning, Anna.
I am also joined by Pedro Martins, my colleague and partner of PGMBM. He is particularly focused on the cases, on the practice of the firm that relates to Latin America, so deeply involved in cases of climate action. Good morning, Pedro.
Hi, Anna. Good morning. Good morning, everyone.
I am myself director of the litigation finance practice in PGMBM. And along with Pedro, we are members of ILAJUC, the Institute for Access of Justice in Latin America. We are proud to say that ILAJUC is also supporting this event. And if you don't know yet about how this institute can develop the access of justice in our continent, please type ILAJUC and search more about our projects in social media, LinkedIn, Instagram, and all of them. Well, I think that now we can start. Pedro, the idea of this panel, as I said, will be to talk more about all of those specific themes of climate action, advocacy, and how they are connected to provide for a better climate for our entire planet. I would like to invite you to start our panel and our presentation, please.
Thank you, Anna. Hello to those who are watching us. Thank you very much for your presence today. Hello also to Pedro Artung and Tomás Jatobá, good friends. It's a pleasure to share the screen with you today as well. I'd like to start our conversation by bringing some facts to answer this question, which is the one that drives the subject of climate change litigation. How is Earth doing these days? Unfortunately, I don't have many good news. Over the last 40 years, with the increase of unregulated industrial production and consequent increase in the emissions greenhouse gases, humankind have been experiencing visible effects of climate change. And I can give you three very simple examples. The first one is the rise in seawater levels, which threaten to flood sea level communities and also increases the destructive potential in case of heavy storms. According to the Met Office, 4 in 10 people live within 100 kilometers from a shoreline and are at risk of flooding if sea levels continue to rise. Second one is the increase in average temperature. This, I'm pretty sure everyone is familiar with this one. It's in the news quite often these days. The increase directly threatens agricultural systems and human health. Air pollution imposes many dangers to children's health. In fact, it is the leading environmental health risk factor globally, contributing to diseases that account for almost 1 in 10 of all deaths of children under the age of 5, according to UNICEF. And a third very descriptive example of what we're living these days is the longer droughts and acidifying oceans that are now being perceived by the entirety of Earth's population. The Intergovernmental Panel on Climate Change working group under the UN has published a report last August this year, which was a code red for humanity. They said, and I quote, "The alarm bells are deafening and the evidence is irrefutable. Greenhouse gases emissions from fossil fuel burning and deforestation are choking our planet and putting billions of people at immediate risk. Global heating is affecting every region on Earth, with many of the changes becoming irreversible." The same IPCC says that 1.5 degrees Celsius average rise may put 20 or even 30% of all species on Earth at risk of extinction. And global warming is likely to be the greatest cause of species extinction in this century. There is an undeniable and significant costs in dealing with all of this, both from a financial and also, more importantly, from a human perspective. This cost is unfortunately sustained primarily by governments and us people. In the last decades, we seem to have started to wake up for the problem of climate change, and across the globe, there were legislative efforts to create laws and policies towards climate action. At a domestic level, these laws and policies create specific obligations to polluting actors and recognize new rights to those that are affected. At an international level, the ultimate effort to address the problem resulted in the signature of the Paris Agreement, which I'm sure you are all familiar with, under the United Nations Framework Convention on Climate Change. And also in the inclusion of climate action as one of the 17 Sustainable Development Goals that are part of the United Nations 2030 Agenda for Sustainable Development. But you might be asking, well, what role does litigation play in all of this? Thank you, Douglas. The efforts of the legislative and executive powers are often not enough and fall short either from a conceptual point of view or an enforceability point of view from what is necessary to tackle the problem in full. This was recognized by country leaders themselves, who during an informal leaders meeting that happened in September 20th, 2021, so a couple of weeks ago, stated publicly that the current commitments are simply not enough. In addition to that, and this is very well put in a 2007 report that was published by the UN Environmental Program together with Columbia Law School, the players, and by players I mean large companies that are either from the energy sector, the food industry, car manufacturers, these players are best suited to fight climate change. And they are the same ones who are heavily responsible for causing it. And they lack incentives to take action. This problem is made worse by an important asymmetry. But these companies have concentrated interests and good access to information, for example, in respect of alternative sources of energy. On the other hand, the ones that will most likely carry the burden of dealing with the adaptation efforts that will need to be made, they have diffuse and decentralized incentives and lack information about the benefits of seeking alternative sources of energy. Litigation then presents itself as an important tool to press for better laws and its enforcement when targeted at governments, and also to disincentivize private actors to act or omit themselves in ways that fail to either mitigate or improve the current situation in respect of climate change. Currently, in general, in both scenarios, what is being sought, it's either what we call adaptation or mitigation measures. By adaptation, I mean the act of trying to anticipate the adverse costs of climate change and also to take appropriate action to prevent or minimize the damage that they can cause. For example, building defenses to protect against sea level rise. On the other hand, mitigation means making the impacts of climate change less severe by preventing or reducing the emissions of greenhouse gases. And in that, we have very good examples of governments trying to impose targets for companies to reduce gases. Within the scope of what is called climate change litigation, scholars consider that there are five types, or five areas of practice that can be identified. First one is constitutional law. It basically focuses on breaches of constitutional rights, either by states or by private actors against its citizens. A very good example of an obligation that is sourced based on the Constitution is Article 225 of the Brazilian federal constitution, which guarantees and grants everyone the right to a healthy environment. Second one is administrative law. So basically, litigation that's done at an administrative level, and it aims at challenging the merits of administrative decisions within the existing on the books laws, such as, and I think this is the most common example, the granting of permits or permissions for high emissions projects. This generates a lot of litigation, has been generating a lot of litigation. Also, in private law, we have a few examples. This relates to challenging corporations or other private organizations for negligence or trespass or unjust enrichments. In this area, we notice a lot of difference between civil and common law countries. The former seem to offer more reliable sources of obligations based on statutory law that can be used as cause of action in courts, while the latter, at least to my mind, still struggle a little bit to coordinate existing concepts under the common law in respect of nuisance and duty of care, for example, with the change in the landscape for climate protection. We also have human rights law, and this is a very important one. Courts are starting to recognize that claiming failures to act on climate change is also a failure to protect human rights, which is very, very useful, given the more widespread and consolidated sources of law in respect of human rights abuses. Last but not least, we have fraud and consumer protection. Typically, this challenges companies for misrepresenting information about climate impacts. And here, one may think that consumer law would be contrary to the protection of the environment, since its essence is to protect an actor that is engaging with consumption, which ultimately leads to consumption of natural resources. However, the Dieselgate litigation is a good example how consumer law protection can also have a positive externality on climate change. The Dieselgate aims at protecting the consumer's choice. The Dieselgate litigation aims at protecting consumers' choice for greener cars, for cars that emit less gases. The positive outcome of this litigation has led all major car manufacturers, and by positive outcome, I mean so far the one that was acquired in the administrative instance with all the fines that have been imposed by different regulatory bodies, but also in the US in court proceedings. So the positive outcome has led to all major car manufacturers to completely shift the industry, starting with VW, and to actually invest in green models and to flood the market with options that are protective of the environment. This looks, I know that this looks good in theory, but I'd like to show you a little bit more of what's happening in practice. The climate change laws of the world, which, by the way, is a very robust and easy to use database for those who are with us today that are interested in learning more, shows 1,841 cases of climate change litigation filed before courts in 39 different countries and 13 international or regional courts or tribunals. This data was last updated in May 2021. The cumulative number of climate change related cases has more than doubled since 2015, which I think is in line with what I was saying before of the awakening of society. Around 800 cases were filed between 1986 and 2014, while more than 1,000 have been brought in the last 6 years. Traditionally, and I think this can still be perceived, this is still true, the predominant argument was to challenge government decision-making under climate legislation. The number of cases challenging government inaction or lack of ambition in climate goals and commitments continues to grow. We have 37 today systemic mitigation cases that were identified by this database. In 2021 alone, 80% of the climate cases identified by the climate case chart in jurisdictions other than the US were filed against governments. However, and this is where the interesting bit is, however, suing corporations for the impacts their business have onto climate change and related environmental issues has been a growing trend, specifically in recent years. This means that it seems claimants are now experiencing a shift from holding only governments accountable to also invoking the responsibility of corporations for these violations and for the effects of their activities on the climate as a whole. These cases seek to establish corporate liability and seek billions and billions of dollars in damages to pay for infrastructure investments for climate adaptation. It's also possible for us to observe that more diversity in the arguments supporting these claims have been appearing. An increasing number of claims focus on financial risks, fiduciary duties, corporate due diligence, and this directly affect not only fossil fuel and cement companies, but also other stakeholders, such as banks or pension funds, asset managers, insurers, major retailers, so forth and so on. So this increases the scope of who can be a defendant. This increase.
Something that you mentioned in the beginning that I would like to ask if you see that this shift in the argument, this new, I wouldn't say new approach, but this second approach, I would say, to hold corporations liable, not only governments and not only to pressure governmental institutions. Because at the beginning of your presentation, you mentioned that the lack of incentives that corporations have to act on climate change. And you also mentioned that the burden of adaptability, the financial burden of that, most often falls over the population that suffered with the consequences of the wrongdoing of the polluting act, but not on corporations. So it seems to me when you're saying that private litigation and this shift in argument, holding corporations accountable, could be a tool to foster or to provide incentives for corporations to change their practices, to adapt their practices by posing financial burdens over their assets, right?
Well, absolutely. I think that's the main power that climate change litigation has. We know that corporations respond to pressures on their shareholders' pockets, right? So I think these attempts are indeed attempts to shift the burden from the population to the corporations, which are the ones that are more capable of carrying this burden as well. So indeed, by if this trend gains strength and more corporations need to pay not only administrative fines, but also compensation within the civil sphere, I'm confident that this would probably lead to a shift in behavior. As you mentioned, the consumer law case with Dieselgate is a very clear example of that. It's just a matter of you comparing how many electric cars were available in the market prior to the Dieselgate scandal and after that.
Yeah, it's also interesting to see that some litigations do hold a strong, I would say, or first at a first glance, you can identify those litigations as a huge climate action, as a, for example, talking a bit about our portfolio, that the case that we do have in that PGMBM leads. So, for example, the case against BHP because of the collapse of the dam in Mariana, or Tevsad because of the collapse of the dam in Brumadinho, or against Norsk Hydro because of the pollution of waters in Brazil as well. Well, at the first instance, you can see the environmental benefit of this litigation, but it is true, however, that some of them, for example, you were mentioning about the Dieselgate, sometimes people could have the impression that it's only about consumer protection, which I would say that it's enough to be fair enough to fight for. It's a fair enough cause to fight for. But it is true that what's underlying behind of that is not only the fact that those manufacturers were in breach of the regulation and did so on purpose, but also the consequences of that, not only the breach itself, but how the market will behave after this rebalance of strengths, I would say, or posing the burden where it lies. Whereas, as you said, those that suffer the consequences of the Pollution Act, the Pollution Act, that means in respect of polluting air, all of us, are not those that profit or benefit from the polluting practice. So this is something that I find particularly interesting when we're talking about consumer practices and protecting consumer choices. But on a second instance, we are actually talking about a larger asset, like the environment, a collective asset.
No, absolutely. I agree. This is particularly interesting, I would say, in the context of transnational litigation. And I know that Pedro will discuss this in a moment. But one of the things that often arise in transnational litigation when you're talking about consumer protection or environmental protection is the double standard that is used by companies in the north of the globe and in the south of the globe. And they hide behind the argument that countries in the global south have different standards than the ones in the north, and therefore they are protected. But I think there are very strong arguments to say that this double standard that is applied, irrespective of it being provided for by domestic legislation in the global south, should not be a reasonable defense for these companies. And with this, it is possible to start changing the mindset of how these international companies operate globally. I had brought a few examples. If we can move on to the next slide of the next. Next one. Yeah, I had brought, and now I'm heading to the end of this opening line. I had brought examples of both cases against a government and also against corporation. 3 cases against governments. The first one is a very famous one. It's from 2019. The Dutch Supreme Court upheld an order of the Court of Appeal in the Urgenda Foundation versus the State of the Netherlands case, in which the Dutch government was ordered to reduce its greenhouse gas emissions by 25% by 2020. And it was given a very strong consideration, I would say, was given by the Supreme Court for upholding this order, which was that it was without the sufficient reduction of emissions of greenhouse gases. The possibility of dangerous climate change will materialize in the foreseeable future. The second one is from Portugal. This was last year, 2020. 6 young individuals brought a crowd-funded case against 33 member states of the to the European Court of Human Rights. It's very interesting that it was crowd-funded. I'm sure Tomas can say 1 or 2 words about that. They allege that the 33 member states share responsibility for their contributions to territorial emission rates and for the impacts of climate change caused by transnational emissions through fossil fuel extraction, trade, and outsourcing. The third one that I brought was also in 2020. This is from the UK. Friends of the Earth filed a case against UK Export Finance, basically challenged the UK government's decision to provide £1 billion in financing for a liquid natural gas project in Mozambique. They allege that the project violates the Paris Agreement commitments. These are all examples of cases against government. Moving on to the next slides, I brought a couple of examples of cases against companies. These are very, very interesting ones and deserve attention. In May 2021, the Dutch District Court of Amsterdam rendered a similar decision, similar order to that from the Urgenda Foundation case that I just mentioned. However, this time it was directed at the parent company of the Shell Group, the Royal Dutch Shell. In the decision, the court ordered the reduction of CO2 emissions by at least 45% by the end of 2030, relative to 2019. And here too, climate change arguments were at the forefront, with the Dutch District Court recognizing that the unwritten standards of the case, as provided for in the Dutch Civil Code, creates an obligation for the Shell parent company to, and I quote, contribute to the prevention of dangerous climate change through the corporate policy it determines for the Shell Group. The most interesting feature of this case was that in interpreting this unwritten standard of care and in defining its scope, the court relied on provisions in human rights conventions, such as the right to life, as provided for in the European Convention of Human Rights. So in a sense, we can implicitly say that they accepted that these human rights standards apply to corporations as well. In a similar fashion, in March of this year, 2021, a coalition of 11 NGOs sued the French supermarket Casino for its involvement in the cattle industry in Brazil and Colombia. The plaintiffs allege that those activities fail to fulfill the standards that needed to be fulfilled and cause environmental and human rights harms. And they seek to compel the supermarket chain to comply with their obligations under the French duty of vigilance law and pay compensation also to the affected indigenous communities in Brazil. Last but not least, I think it's important to bring one example of the development of more sophisticated laws that reach corporations. Sorry, we can move on to the next slide. I'm sorry, everyone, I don't have control over the slides today. In June 2021, The German Parliament passed the legislative proposal enacting the Supply Chain Due Diligence Act. That's how it's called. This bill imposes an obligation onto corporations to fulfill their responsibilities in the supply chain regarding respect for internationally recognized human rights and certain environmental standards. And the adoption of that, I think, very much signals the start of a shift in the mindset. So from a strictly voluntary corporate social responsibility towards a binding human rights and environmental obligations for companies. So the further increase of pressure on governments and corporations through climate litigation suggests that in the future, governments may be more inclined to adopt similar legislative approaches, which, to my mind, would benefit all of us, society, a lot. Well, now heading to the end of my initial participation, I think we as a law firm need to be ready to fulfill our role as a vehicle for claimants to seek redress and other remedies via court cases, and do our part, of course, in trying to mitigate the impacts of climate change. We have a very important advantage, which is that we litigate globally, and this allows us to know how to navigate different jurisdictions and understand the bottlenecks in each one of them. For example, a common obstacle in all of these cases for the claimants is that of standing to sue, to determine if the claimants have standing to sue or not, and what type of damage can be pleaded. There are some very unfriendly jurisdictions in that regard, which impose high thresholds to allow claimants to proceed with their case, while others don't. The Brazilian procedure and material law, for example, is quite friendly in that regard, in respect of standing. In Brazil, we have provisions that allow for the possibility of collective damage being pleaded and grants private actors, associations, the possibility to seek decisions that will benefit society as a whole. At the same time, court proceedings in the Global South usually take a long time. So this balance between advantages and disadvantages is definitely a challenge that litigants must be alert to. Well, that said, I'll pass on to Pedro Hartung, our friend and partner in one of these litigations. Thank you.
Hi, everyone. So thank you for the invitation. It's great to be here with you today to discuss this very important topic that we should, as NGOs, as legal professionals, we should discuss and we should take action to change the threats that we are facing right now. And my first brief talk, I want to divide in three main topics. First, to talk with you about Alana and what we do here in Brazil and worldwide. Secondly, I would talk a little bit about our perspective, and also from a global South perspective, with focus in Brazil, what is climate action and what different kind of advocacy strategies that we have at our disposal. And third, I want to highlight the importance to connect different topics, and not just from legal perspective, but also from social perspective, especially human rights and children's rights. So first of all, ALENA is a system of social environmental impact organizations that promotes children's rights to integral development and fosters new forms of well-being. Therefore, it's organized into three fronts: the ALENA Institute, which is the NGO, the ALENA Lab, which is a holding of impact enterprises for social good and B enterprises, and ALENA Foundation, which is a philanthropy institute or organization in the United States. We have already developed climate action advocacy strategies in those different three fronts. With the ALENA Lab, we have already developed different products through entertainment and documentaries about climate causes, and we brought social, environmental, and climate topics to a large audience, such as Aruana's TV series. I don't know if you know that, but you should check it afterwards. That we produced with Rede Globo, which is a big producer, TV producer here in Brazil, and you can find in Globoplay, which is their platform, and the documentary The Beginning of Life, the second out there, which is internationally available in Netflix. About this is specific about the importance of the children's or the child's connection with nature. Inside Alana Institute, we have different programs and projects that specifically discuss the rights of children in different topics, but also to their right to a balanced and healthy environment, as mentioned, as Pedro mentioned on the Article 225 in our Constitution. And as we call it, we want to bridge the 225 with the 227. And the 227 is the one that brings children absolute priority. We have this in our Constitution. Children, they received from all of us in our Constitution absolute priority for their rights and for their best interests. Inside Alana Institute, we have another program called Child Nature. And inside this program, we have the project on climate justice, through which we developed different actions on social and environmental issues and on climate, such as about 7 amicus briefs on our Supreme Court to highlight the absolute priority of children's rights in relation to social, environmental, and climate topics. I don't know if you know, but in Brazil, we have a very solid legal framework for protecting children and the environment. What is really lacking is the enforcement. That's why climate action and litigation advocacy is very important, and also funding for that is essential. I really liked the name of the panel because indicated that it's not just about litigation. And we usually say climate litigation and everything is about litigation right now, isn't it? Including funding. But my main topic here is to highlight the importance of a broader perspective on litigation that need to combine different advocacy strategies, not just litigation, but of course litigation, but not just it, as communication strategies, campaign strategies, and funding should also be available to or be open to those different kinds of advocacy strategies. So that's why I liked a lot the climate action and not just climate litigation. And the second point that I want to highlight here today is about a global south perspective on climate action or litigation. As you may know, Brazil is currently going through a political and democratic crisis by which the duties of the federal government are not being met as expected and as demanded by our legislation. And the lack of political will and the effectiveness from executive power branches to tackle the climate emergency is evident. The judicial system has become right now an important space of a very important space, not only to demand the executive power to do their job and the legal demands, but also to guide the public agenda on urgent problems. So that's why we need to connect litigation with communication strategies, because it's a way so we can bring to a broader audience or to the public agenda the topic related to our litigation. Sometimes it's not the litigation that will solve the problem, but the litigation will be the vehicle that we can discuss the problem in the press, in a larger audience. So to connect those dots is very, very important, including in funding. The judicial system, however, our judicial system, and we could say in many of the judicial systems in the global south, have structural problems related to different obstacles, but especially with the timing of the actions and the imbalanced power between the parties involved in the process, especially when companies or even when corporations they are involved, because they hire the best lawyers and the best legal help available, and in the other side, and also different researchers and different all the kind of tools that they have that the money can buy actually. They use this in the legal battles. So it's very important that we understand that the the judicial system in the North is very different from the judicial system in the South. So to have different strategies and to fund different ways to tackle this, it's very important. Therefore, as I said, advocacy strategies must not only understand litigation, but also must comprehend communication and press relations strategies, mobilization and awareness campaigns for society and to create this public agenda, monitoring of agendas in other powers, such as the new regulations in the parliament or regulatory policies and supervision in the executive, especially because we know that the dialogue between institutions is right now very fast. For instance, a thread of a decision in our Supreme Court is capable of moving projects or bills inside our parliament that would take years within a common period, for better or for worse. So they dialogue a lot, and sometimes we need to also cover these dialogues to really bring effectiveness to our climate action and or litigation. Therefore, as I said, the funding should also connect and really pay attention to that and help actually civil society to create those kind of strategies, broader strategies. Furthermore, climate action litigation strategies must consider issues beyond the climate, in particular human rights and especially children's rights, the most affected by climate change. So that's, and I think this is very important for our future agenda. We need to connect health, we need to connect human rights, children's rights to the climate agenda, and especially in our litigation and advocacy strategies. Almost every child on Earth is exposed to at least one of the climate and environmental hazards. Without urgent action, this number will go up for sure. 1 billion children at extremely high risk and 33 countries of the impacts of climate crisis, according to UNICEF. So we have 240 million children are highly exposed to coastal flooding, 330 million children are highly exposed to riverine flooding, 400 million children are highly exposed to cyclones, and 600 exposed to vector-borne disease, 800 million exposed to pollution, air pollution, 820 million to heat waves, 400 million to water scarcity, 1 billion children are highly exposed to high levels of air pollution. So almost 90% of children in the world are exposed to air pollution. These children experience multiple climate shocks combined with poor essential services such as water, sanitation, and healthcare. As climate change disrupts the environment, children are being forced to grow up in an increasingly dangerous world. This is a crisis that threatens their health, nutrition, education, development, survival, and even their future. So it's a social and economic crisis. Climate change is not just a human rights crisis, it's an economic crisis. And to tackle that is to deal with the sustainability of our economic itself. Actually, climate change is deeply inequitable. While no child is responsible for rising global temperatures, they will pay the highest costs. They are paying actually, right now, the highest costs on air pollution. They are dying more because air pollution. And actually the children from countries least responsible, especially here in the global south, are suffering most of the consequences. So that's important to know that many of our problems that we face right now in Brazil and all Global South are originated from international companies or corporations supported by their states. A lot of states, they are part of the corporations, like Germany and the automobile industry, which operate with, as Pedro said, double standards. And I would call a logic very much guided by a new colonial standard, or we could call new colonialism, but no longer directly by the states, but by their companies or corporations. While in the countries of origin, they have less polluting technologies, they follow corporate policies based in all SDGs and green economy and etc. In our countries like Brazil, or other Latin Americans and African countries, which is even worse, we receive obsolete technologies to increase the cost effectiveness of these corporations. That's why it's so important to consider in advocacy strategies transnational actions, as Pedro said, including coalitions with civil society organizations from different countries with the support of the local legal community. And funding should also understand and highlight that. It's not easy to connect civil society around the globe, but it's essential to deal with all this transnational climate crisis that we are dealing, especially because the corporations, they are also transnational, and they're treating actually children from different countries, especially in the Global South, in a discriminatory manner, something that we could call also as an environmental and climate racism or discrimination. So lastly, I would like to highlight the importance of funding to create this advocacy climate actions, litigations, and also civic society coalitions around the globe. I really think that the support of the legal community, law firms like you, it's not just important, but also essential. And I think the bridge that you guys are doing right now with those debates and also the litigation will change the landscape of the climate crisis they are facing, especially in this Global South. So thank you.
Thank you, Pedro. Thank you. Amazing presentation you both, Pedro, did with such important topics. And I couldn't agree more. That's, I mean, litigation, the way we think litigation within PGMBM, it's not an end in itself. Litigation for us is a means to reach a desired outcome, whether like to proper redress for specific victims that we are protecting as our clients, or to provoke either a behavioral change or a policy improvement. We have other tools, and just the mere fact that litigation is possible, that corporations can be held accountable for their practices, is itself a provocation, a not gentle, a hard push, a hard nudge, I would say, to better alignment of their practices. And it's very also important how you highlighted that human rights and student rights are all connected with environmental rights, and climate change itself as economic crisis. It's shockingly to say how long financial and capital markets took to wake up to that and to divert capital to this kind of causes, not only on litigation, but on less polluting practices, less polluting products, less harmful conducts. And I also thank you very much for providing already the hook for the litigation funding practice, for the funding general practice. So I don't even have to do the link because you already did it perfectly. So thank you. But Douglas, if you can pass to the next slide, I would thank you very much. Because now, as Pedro said, funding is important, capital is important for this fight that we are conducting tackle climate change, to tackle those effects, and to protect those that are more vulnerable to their effects. Third-party funding for climate litigation is one of those practices, I would say, how to use capital towards this goal. And it's not obvious for everybody. I know that we have attendants here that are focused on litigation funding practices that work in PGMBM, but also environmentalists and people that are not familiar with that. So I would just briefly try to tell you why is it important. So there are many risks associated with filing a climate litigation and starting this lawsuit. So we have to think about the financial risk itself, because, well, you can lose your litigation. That's something that you have to think about. Other operations involved with that. Think about, for example, our emissions case that we were talking about against the car manufacturers. We have to perform the research, understand what happened, which manufacturers, who bought those cars, what models contain that specific device that we are litigating about. And other costs also in respect of insurance in case we have to provide as a law firm. Actually, the plaintiff has to provide it in case the litigation is lost, and also other demands in respect of the cost of litigating itself a case. When we are talking about cases that tackle this specific global south versus north problem, so again, talking about environmental litigation that PGMBM leads in respect of facts that happen in Brazil but are litigated in Europe, we have an extra cost to try to bring those specialists in Brazilian law, those the victims, those specialists in the Brazilian environment also to Europe, and try to provide knowledge in respect of what's happened in a different jurisdiction. Or it is true also talking about PGMBM portfolio, not all of our cases, those international cases, relates to facts that happen in Brazil. We also have a case file that relates to very sad facts that happen in Africa, precisely in the Republic of Chad, for example, and we are developing and researching cases also in respect of the broad Latin America. Of course, we also have the legal fees, the lawyers' fees, barristers, if we are litigated in the UK. So it's quite costly to litigate those kinds of actions. And Douglas, if you can go to the next slide. And when we consider who are our clients, so those that were affected by the incident, and those that we are trying to protect. So of course, the way that PGMBM found, and other law firms as well found, is to charge contingent fees. So of course, the clients will not pay anything upfront, but in case the litigation is successful, PGMBM will retain as a fee a percentage of that, which will vary depending not only on specificities of the case, but also who are those clients? Are those indigenous populations? Are those diesel vehicles owners? This all is put into account, and this is necessary because, as we will discuss with Tomás Jatobá, this is what provides collateral, so financial security for the funders that will invest in this cause, and provides the capital that is much needed to cover all of those costs that I talked about in the previous slide. So to properly fund the litigation and make it possible. So when we're talking about contingent fee agreements, we are actually talking also about access to justice. So coming back to what Pedro Martins said in the beginning of our presentation, we do have a strong imbalance of power between those that provoke the problem, that cause the problem, and those that suffer to adapt to the effects that it caused. So we're talking about super, I don't like the term rich, but wealthy corporations held and by other wealthy holding companies mostly located outside, very, very far away in different continents than where the operation itself was, and where the effects of the collapse, of the pollution, of the wrongdoing was suffered. So finding capital to litigate those causes, to fight for this is important, not only to protect the specific victims, but try to rebalance this unfair scale that we have between corporations and the population that suffer with the consequence of their transactions. So it's about access to justice, but it is true that there are some specificities in the agreement itself that we have to think about carefully when redacting it, to be 100% sure that it will be acceptable in the specific jurisdiction where we are litigating. Some jurisdictions just does not accept this kind of fee arrangement between lawyer and client, and this is also something that we could think about a potential positive policy change in the future, and understanding that contingency fee agreements can also be an instrument to access of justice when well used, when used within the limits to provide access to those that otherwise couldn't have that. At this point, I would like also to invite Tomás Jatobá to talk a bit about litigation funding, and in respect of what is this? It's true that your fund does not only do that, but in respect of litigation funding, what you look for when you're looking for what causes that you will fund, or what is important in your due diligence process? I would like very much to listen about that.
Well, of course. Well, thank you very much, Anna. It's quite hard to speak after all those specialists have spoken, but well, SPS has like many strategies, but I think like my personal favorite one is litigation funding, because it's basically granting the resources for those who have rights, but they don't have resources to go after and chase their rights. So that said, the first question we ask ourselves, for example, for every strategy, we have a set of 5 or 6 questions that we have to answer before deciding whether to move forward or not with the transaction. And for example, it's not a litigation funding, but a common funding transaction. One question is, is this business ESG friendly? And it's not only because ESG is now fashionable or anything. ESG now is a reality. It's not because you do not have to think that, oh, I have to be ESG because I want to be a good person. It's a matter of economy, like the non-ESG business, they are fated to be dying businesses. They will be hard to finance. And so why would I invest in something that is fated not to exist in 5, 10, or 20 years? So, for example, why should I rent money to a coal power plant, or for some company that would be like involved in environmental disasters? Because if there's a disaster and then there's a litigation that will hold the companies accountable, they will eventually be in financial distress. So I think the ESG investment is a reality in the world nowadays, because the capital itself is compelling companies, and it's really important that finally the owners of the money are aware that they have the power to compel people to do the right thing. And when I say that, like in the broader context of ESG investment, when you go to litigation funding specifically, I call it like it's ESG plus, because it's not that you just taking care that you're not putting you in risk because of social and environmental risks. You are actively promoting the improvement of standards, the improvement in holding companies that to be held accountable. And that's in the interest of the entire society, even of the market, because if some companies, no one wants to be the fool. So no one wants to be the only company in a specific market that wants to abide by the rules of the treaties of admissions and etc. Because they would have to compete with companies that do not abide by those rules. So it's completely necessary that there's a broad framework of legislation that applies and it's enforced against all the players in the market, because otherwise you will have unfair competition between those among those who follow the rules and those that do not follow. And that ESG plus, they say that when it comes to litigation funding, the first questions of the 6 questions that I will have to answer when deciding to fund the litigation is, are we on the right side? Because it's not, well, besides that, no one wants to be funding the bad guy. Second, we do believe that judges, they should be at least more prone to hand down rulings that benefit like poor and the victims than the big companies. At least they should. and because whenever, well, my business is about every other time raising capital, and we are, for example, we are now currently raising our 3rd fund, and our 2nd fund was raised like 2.5 years ago, more or less. And 2.5 years ago, almost no investor would ask me, oh, what do you, besides your investment, I understand the return, etc., but what about the society? What about you do? Even in the person of the partners, do you donate to NGOs? Do you engage in some social work? And in respect of the portfolio, the investment, what do you have that I can tell my clients that their money are not going into harmful activities, or that are you at least actively acting on something that they won't sleep thinking that they are funding guns, or instead of funding, well, the victims of collapses. And the new colonial mentality that Pedro was saying is really, really strong, and especially because the litigation industry in the global south is way more underdeveloped than it is in England and in Europe and etc. So as one of the few litigation funds in Brazil, we feel the responsibility that we have to hold the foreign company accountable, even because, like, as it was already said, the Brazilian framework, environmental framework, is actually really good. The problem is that it's not enforced. So what I think that is the great idea of PGMBM, and we are really happy that we help them to reach that, is that you take the Brazilian framework, but you take it out of the Brazilian enforcement problems and then you litigate whenever, wherever it's possible. That would be easier and especially faster, because the problem is that in Brazil, any litigation could take like 20 years easily. And you take to jurisdictions that are friendlier, and even in those jurisdictions apply the Brazilian framework. So it's the great combination. And when the companies say that they would not receive, oh, just a little fine in Brazilian reais, but they will have a real indemnity to pay in hard currency, in strong currency, they will sure think twice before they have those double standards of, in Brazil, in Africa, they use all the old standard stuff, and we leave the good, well, the more modern and clean stuff to Europe and US. And just that's because the new colonial thinking is not exclusive of the companies. It's basically, oh, whenever an accident happens in Brazil, people the board members or everyone, like even in Europe or in the US, would probably 1 month later forget about it. And so that's why I think that it's really important that the litigation funding industry is widespread in the world. Then you have different players that would be always searching for these opportunities. That, of course, most of them are for profit. But when you can do it for profit, but do a much bigger good to society, is the best way to earn money. So people, you don't have to segregate what is there's a false dichotomy between capitalism and earning money with being green. We have to end with this dichotomy. You can be in a capitalist society, you can work to earn money, but you also, that doesn't mean that you do it at any cost, and that doesn't mean that you can use your money to promote the good in the society. I think basically that.
Thank you very much, Thomas. Very nice to listen to that. So, and to see that the climate impact is being is already within the mechanisms to measure financial risk within the ESG metrics, but also when you say ESG plus, we can also talk about social impact, not merely saying that this business will not collapse because of any climate action, but we are doing actively something on climate, on human rights, on children's rights, or women's rights, and other causes that are so important. Also, I call attention to something that you said that links with something that Pedro Arton was saying, is that corporations are made of people, as you said. Not only corporations, but also people. And corporations are made of people. Therefore, creating awareness to the impacts of climate change by any means whatsoever, litigation, communication, advocacy, public relations, has the power to change people's mentality and therefore influence corporate behavior and policies more in general. I'm very happy with this panel because I see that there was a nice flow and different themes that could seem so apart one from the other. Without a lot of preparation, I have to assume for all of us that are listening to us, we got to connect everything very, very smoothly, and I'm very happy with everything that I learned today. I would be happy to ask if one of the participants have a comment or any final remarks, and would be happy also to open for someone's question if you have. We only have 5 more minutes, so not long. So no final remarks.
Can I then just say one thing that came to my mind while I was listening to both Pedro and Tomás and yourself, Anna? And I think this is important because it is a common obstacle in pretty much all of the litigation involving climate change. It is a legal obstacle that, in order to be overcome, demands a lot of funding, and it's the one of causation. One of the main hurdles that litigants face while trying to obtain redress in private actions is to establish that a particular emission is the proximate cause of a particular adverse climate change impact. And in order to establish this link, you need to provide expert and technical reports. And this is very expensive. So I think this is one very good example of how funding can help to unlock one obstacle that is common and that, without being overcome, it's going to be really hard to provide people with redress.
Thank you very, very much, Pedro. Thank you, everybody who joined us this afternoon or this morning, depending from where you're dialing in, and have a good day.
Thank you. Thank you, everyone. Have a good day. Bye-bye.
Bye.
Everyone, thank you.
Thank you, everyone.